there's a good chance that if you're watching this, you know that I just went to court and a psychiatrist recommended that I was declared incompetent. This is the psychiatrist from the state hospital who works for the court. The judge agreed. He said I was incompetent, and I told him I have a right to appeal this. I'm going to go hire an outside psychiatrist. And so when I talked to this guy from the state hospital, I told him, I said, well, here's the thing. It's not your job to determine whether or not the CTO of the NSA hired me to work as a contractor for him, and if the CTO of the NSA told me that I worked for Donald Trump. It's your job to determine whether or not I understand the trial, like whether or not I understand like the prosecution and what felony menacing is. And felony menacing means that I am threatening imminent danger. And clearly I didn't threaten imminent danger. He asked me, what do you think is your best legal defense? And I said that I didn't threaten, I didn't actually meet the definition of felony menacing. And he said, well, what do you think is their best case they have against you? And I said, the best thing they can say is that I'm crazy because I said that I worked for Donald Trump when I did. And I said, but the thing is, it's not your job to figure out whether or not I worked for Donald Trump. Like, it's your job to figure out if I understand the court case. And so this psychiatrist apparently didn't care about anything I was saying, probably because some people were lobbying him to declare me incompetent. But so I looked up the definition of incompetent based on, in legaldictionary.freedictionary.com. And it says, in criminal law, the inability to understand the nature of a trial. In these cases, defendant is usually institutionalized until such time as he/she gains sanity. Okay, and then here's something written by someone about incompetency. It's written by a lawyer, and it says, in criminal law, a defendant's mental competency may be questioned out of concern for the defendant's welfare or for strategic legal reasons. The defense may request a competency hearing so that it can gather information to use in plea bargaining to mitigate a sentence or to prepare for a potential insanity defense. Okay, so talking about a motion for in federal court, a motion for a hearing will be granted if there's reasonable cause to believe that the defendant may be suffering from a mental disease or defect rendering him mentally incompetent. A psychiatric or psychological evaluation is then conducted in a hearing held on the matter. If the court finds the defendant is incompetent, the defendant will be hospitalized for a reasonable period of time, usually no more than 4 months. The goal is to determine whether the defendant's competency can be restored. So if they put me on drugs and ruin my brain, because I'm a sober person, I don't take any drugs at all, like I don't even drink caffeine, then they can restore my sanity for when I stand trial. So I have to get my sanity restored or my competency restored before I stand trial, but clearly I understand my legal situation. I mean, dude, if there's anything I understand is how serious this is. I'm not a felon. I have no criminal record whatsoever. The problem is I think that they need me to be declared incompetent because I already got put in jail for this crime that I never committed. Like I already spent almost 21 days in jail because I was in contempt of court. And okay, so the Jackson ruling also specified that treatment must stop if there is no substantial probability that the defendant will regain trial competence in the near future. If that decision is reached, the defendant can continue to be detained only if they are declared permanently incompetent in a civil commitment proceeding. The development of powerful drugs has given the government the opportunity to medicate mentally incompetent defendants to the point where they are competent to stand trial. By 2003, the federal government was medicating hundreds of defendants each year, but a small number objected to medication. The Supreme Court in Sell versus United States issued a major setback to prosecutors when it placed strict guidelines on medicating defendants accused of less serious nonviolent crimes. All right, so I now have to go hire a psychiatrist to determine clearly that I understand I don't understand why the psychiatrist doesn't lose his license for declaring me incompetent. I mean, clearly I understand the nature of my charges. And it's not his job to like start calling up Andrew and being like, hey, did the CTO of the NSA say that he worked for Donald Trump? Yeah, he did. Wow. Holy crap. So, I need to appeal this. The problem is I'm going to have two psychiatrists saying opposite things, and then I appeal before the judge who already put me in jail. This judge put me in jail for contempt of court, and he's going to be the sole overseer of this court proceeding. And so that's a situation I'm in. I can't believe they did this to me. You have no idea that they've done so many terrible things to me, and then they do this to me. Like, it's just, it never ends.